Hi, my name is Andrew Meinzer of Meinzer Law Firm. Today I'm going to talk with you about surety bonds in probates, conservatorships, and guardianships. In California, you need to understand the basics of surety bonds if you're going to be acting as executor or administrator in charge of the probate decedent estate court proceeding, or simply probate, of someone who has passed away. 2, acting as the conservator in charge of the conservatorship court proceeding, or simply conservatorship, for an adult who's become unable to take care of himself or herself anymore. Or 3, acting as the guardian in charge of the guardianship court proceedings, or simply guardianship, for a minor in need of someone to manage their affairs. A surety bond, often referred to simply as a bond, is like an insurance policy. It's a contract through which one party is liable for the debt, default, or failure of another party. For example, when hiring a plumber to fix a dripping faucet, 2 things that people often consider are whether the plumber is licensed and bonded. All other things being equal, a plumber who is bonded probably is the better option. The bond will provide funds to pay for the damages if, while fixing the dripping faucet, the plumber accidentally floods your entire house. Probates, conservatorships involving conservatorship of the estate, and guardianships involving guardianship of the estate all have one thing in common. They all involve one person managing assets for the benefit of another person. In those situations, it's prudent at least to consider adding safeguards, because it's possible that the person managing the assets will mismanage them to the detriment of the other person or even abscond with them, and a bond is one such safeguard. Courts almost always require executors and administrators of probates, conservators of conservatorship estates, and guardians of guardianship estates to file a bond. Normally, the court won't even generate the paperwork documenting the authority of the executor, administrator, conservator, or guardian until that person files the bond with the court. Then, if that person mismanages the assets, absconds with them, etc., the company that issued the bond may be responsible to pay into the probate, conservatorship, or guardianship to replace the lost value. And just know that the court sometimes can waive the bond if it makes sense in a case-to-case basis. As with insurance, various companies are in the business of providing bonds to administrators, executors, conservators, and guardians. Naturally, these companies charge fees in the form of an annual premium for providing bonds. And the greater the assets and income at issue, the larger the bond amount, and the higher the annual bond premium. At Meinzer Law Firm, we have over 20 years of experience helping clients to achieve their goals in probates, conservatorship, and guardianship cases. Again, my name is Andrew Meinzer of Meinzer Law Firm. If you know that you need our help, or if you just have a question, please give us a call and let us take care of you.